दाल लेके रखा है।
I'm for the responding law. The last location, my lord has directed to obtain necessary instruction. If my lord sees the last order, my lord. The last order.
Yeah, I have seen.
Yes.
I'm appearing for
The-
Oh.
to appear with Mr. Prasad for the respondent number 3.
Copy has been served up.
Copy I have received. I have received.
What is clear here today?
Miss-
Oh, you are ready?
Ready in the sense I have received some instruction.
Oh,
My specific instruction here is, first of all, I need to file an affidavit in opposition to this because there are certain submissions made on the records which are not accurate. That needs to be placed first of all. So your honor will give me some time. That is the first part of it. The second part of it, this petition, whether it is maintainable at all, and it has certain defects. So all of this needs to be placed on record.
actually, so some question of fact is involved.
There-
So can I, this matter be relegated to the authority? He will.
I'll tell your lordship what is the problem. First and basic problem. You have a copy. If your lordship sees, the person here. The main person here is someone else. This private respondent is that person's wife. I'll just get the petition and I'll just demonstrate. Or if one of my learned friends just give me a copy for a second.
I have seen it. Yes, that matter. I have seen it. That you took the plea that it is your husband who has done the mistake.
Absolutely.
Yeah. Now husband and wife is taking two different stand.
No, it is not about that. The question is the husband and the wife. The order that has been passed at Annexure P8, page 26. This is done in respect of the husband, Shaji. Kindly see page 26 for a moment. Page 26, which is the order of the Tehsildar.
Yes.
Kindly see 1, 2, 3. Third paragraph, I have deposed that the construction is by the husband and not by her. But kindly see the finding, para 5. The finding is, whereas one Sri Shaji has started construction of RCC structure upon part of recorded government revenue land, along with some portion of land bearing survey number 44/1. So Shaji has done whatever encroachment, assuming or not admitting that there is any encroachment at all, it is done by Shaji. Now, just because I am married to Shaji, automatically I will become a party. My lord will kindly consider there is something called non-joinder of parties and misjoinder of parties. Now, by virtue of the fact that I am a government employee, I am being targeted in the matter by adding the wife in. The wife is nobody. Under what provision of law and
So you may implicate the Saji as party.
Absolutely. This is point number 1.
So I am striking out the name of such and such private respondent.
Now, this is the first thing. The second thing is, what is the order? Kindly see page 27.
Yes.
Now, therefore, this is the fourth paragraph. Now, therefore, under section 161(2), I do hereby order the respondent to vacate the said unauthorized occupation of an area of 22 square meters from the land bearing survey number 44/1 situated at Bimlita, belonging to the complainant on or before Atho, failing which the same shall be evicted on Atho by the revenue inspector, circle number 5, without further notice. Kindly see who it is addressed to. On the left hand side, given under my hand and seal of this court on 7th March 2023, to V. Shaji. The order is directed at Shaji, not at me. Now,
A respondent who were addressed as a respondent
Shaji.
by the respondents.
Yes, but that is why I'm saying in the name where the order is addressed at the bottom, it is addressed to V. Shaji. It is not addressed to Shaji's wife Lissy. That is point number 2. Point number 3. This I'm stating on instruction.
Yes,
I'm
yes.
stating
Yes.
on instruction. This 22 square meters of land that has to be vacated, absolutely it has to be vacated. The problem is, it is a factual issue as to which is that 22 meters of land. this 22 meters of land, there has to be a demarcation by the revenue authorities who are hearing this matter. They are the concerned authorities. They will demarcate that this is the encroached area, because this encroachment that they are talking about, part of it is on revenue land, part of it is on this man's land as alleged. Now, the revenue land encroachment is under some scheme from 1960s that is actually regularized and permitted. The only problem area is where he has gone onto this man's land. Now, the question is this, that who will demarcate it and say that this is the place? That is a factual matter. These revenue authorities are supposed to do it and execute it. We have no difficulty with that. Now, they have come up before the writ court to execute a revenue matter. Whether the writ court will be able to enter into the factual matrix, I am asking myself. So, what fell from your lordship just now? That this is something which has to be relegated to the authority, where the authority has to take a decision and enforce its decision. Matter is as simple as that. Why they are coming before the writ court to try and circumvent the procedure laid out in the revenue laws? Now, this is point number 3.
Now, what is the next follow-up action?
Now, follow-up
would be taken by the Tahsildar in case his order under section 161(2) is not complied.
Now, his order to be, in order to be complied, the demarcation will be done. It will be identified that this line is your land, this line is their land. You vacate this part, you vacate. Matter ends. Instead, what they have done is, this order was passed on 7th March 2023. They have come running to the writ court.
No.
And now kindly see page 28.
So if I disposed of the writ petition by directing the Tahsildar that before implementation of this order, kindly you are directed to make a physical verification and demarcation, that would be served the purpose.
One thing I
The only
I agree with this proposal.
now the problem is that, my lord, on kindly see page 29, I have given a letter on 9th of October 2025 by saying that to execute the order. What they have said, they have not done anything. Thereafter, I have made a certified copy. What they have written, the file is not traceable.
That
Now,
I do
where is
not.
the file? Now, where is the file? How the execution can be done? The file has to be traced out. For that reason only, on the last occasion, my lord has passed.
What is your instruction? File detected.
Authority is here, my lord.
File is located.
File is with the revenue inspector, my lord.
Okay.
Surveyor.
Okay.
File is with them.
Okay.
And now he is.
So don't complicate the issue. I am delegating the issue that you take next step, you implement this order. But before implementation, you make a physical verification and make a demarcation of the land to locate how much portion of the land.
It's mentioned, my lord, in the 161, it is mentioned how much portion they have encroached.
But what is the portion?
Exactly.
Location is required.
Exactly.
It will be.
Now, there's only one difficulty. There's one difficulty which has to be taken into consideration. This order, these hearings cannot be against this woman. She has to remove this.
Okay, I shall say that you raise this point, that it is not you, but your husband has done the encroachment.
But
No,
the complaint
okay.
was lodged against the wife.
I don't have a vakalat
You
nama
took
for the
this stand before the learned court below, and you have been improperly joined.
Yes.
ঠিক আছে?
Yes.
You have been improperly joined, and the case is petition is defective for non-joinder of necessary parties. It is. Our considering fact.
Because
But you said that.
your lordship is not going into the merits. This case, your lordship is not going into the merits at all.
But I am
So-
to take cognizance of your submission that here demarcation is required.
No, because then if that has to be done.
So I am to record that. However, Mr. Kobi says that.
No, the problem is, in order to do that, then this lady has to be removed and that gentleman has to be added.
Their order is
And
to be
then he
passed.
has to be served. Then he will give vakalatnama to someone, because I don't hold a vakalatnama for him. So there is a technical
Right,
issue
my
here.
lord, my-
That's why I'm saying, your lordship may consider here, recording my submissions, that Lissy is not the correct party, that the husband is the correct party, but at the same time, your lordship may record that this is not a matter where the factual aspect can be considered by the writ court, and therefore the matter is relegated to the authorities to act in accordance with law. After making a physical inspection, matter ends. Whether my learned friends have objections to that, I have doubts.
My lord, earlier.
But they have
initially
made
the
a
DC
complaint
was there.
against the wife. my lord.
Now the husband has come. That's the thing, my lord. That's why this stay order is against the Lisi. I have made a complaint against the
Against
Lisi
the
because the Lisi was there. Initially, the Lisi was there. Thereafter, husband came.
Let there be one document showed with my name on
Because-
it. One document with Lissy's name. Let it be
Because
shown.
it's an
My
encroacher.
lord,
Very good. Then-
page
Then,
26.
then just oral submission at the bar will not do that I'm an encroacher.
My lord,
Where is the single document addressed to Lissy?
my lord,
Single
my-
order in respect of Lissy?
My complaint.
No.
against the Lisi-
Oh, I know, madam. Yeah, I know. But after reading this third paragraph
Yes.
of the order, how you have make a party again?
My lord, initially, DC was there. Thereafter, at the time,
Maybe,
after.
but
filing
this is the
complaint-
stand. This is the stand taken by the lessee before an appropriate authority.
My lord, my husband
Which
is
they
there.
have not
Now
challenged.
my husband is there.
Huh?
Now my husband is there.
Huh?
Earlier,
Yes.
DC was there.
Where? Let us see one document also
Oh,
with Lissy's
okay.
name.
Okay, by this time, the court is not powerless to steer the wheel, don't you? Okay,
My lord,
we have understood.
my lord,
And
one more
then-
thing, my lord. My lord, for simple thing, my lord, the petitioner has to come twice before this court. For that, some cost has to be imposed, my lord. Because.
Whom?
Upon whom?
Authority.
Why? Why upon the authority? Authority is
Because
taking
I have got
steps.
the instruction that case file is not traceable.
But the cost is the ultimate desired result. Court is ultimate remedy.
Before the authority is.
Once the cost is imposed, let a cost be.
So if
imposed
you
on-
want determination of cost, I am directing that I am striking of the name of Lissy, you add the Mr. Saji, and I am keeping it for hearing in the next circuit bench. Huh?
Before the authority will do it.
It is for you.
My lord.
You have created a sort of
Yes.
sub dispute.
My lord, Lissy, she has deposed before the authority that her husband is making
That's it.
construction. It is not her that she is making construction. It
Yes.
is on deposition she has stated. She has stated before the authority.
Yes.
It
Yes.
it is a husband. who
So
is
you
making
could have acted on
She-
such stand,
What-
on such stand.
I'll do it.
Acha,
The order is with the, against the Lissy only.
acha, ठीक है. This petition has been papered as taking a directive upon the Tahsildar concerned, upon the
Many-
respondent number 2 to implement its order, to implement his order dated 7th March. 7th March.
Seventh March
Yes,
2023.
7th March 2023.
My lord, 27, page 27. My lord.
2023.
My lord, this order is an appealable order, my lord. If my lord
Oh,
sees the
I'm
regulation,
sorry, that is point number 4.
regulation 28, if my
Under
lord
the revenue
sees.
laws, the land revenue regulation.
Appeal was required to be filed by Saji. Mr. Das. By whom appeal will be filed? Saji?
Saji.
Saji has not papered the appeal.
My lord.
My lord, I'm applying.
So we shall go on waiting for independent period that appeal is here. So he has not availed of the remedy, statutory remedy available to him.
Because
Huh?
Shaji has no problem.
He has allowed the order to attend its finality.
Right.
Huh? কি বলো? Giving a directive to the respondent number 2 to implement his order dated 7th March 2023, whereby he directed respondents to vacate the unauthorized occupation of an area of 22 square meter from the land of the petitioner. Stop. Essential facts which needs to be narrated for the effective adjudication of this writ petition is that the writ petitioner approached the Tahsildar concerned with an application inter alia contending therein that that one Saji, one Mr. Saji has encroached a certain portion of his or her
Yes.
of
Of their.
their lands.
There are two joint
Uh-huh.
petitioners. Two writ petitioners. are-
Acha, of their lands. ঠিক আছে, stop.
This is
Based
the-
on their application,
I don't know if you got the survey number 44/1 of Binditan village.
acha, 44/1,
Area 0.03 hectares.
comprising an area of 0.03 hectares situated at
Binditan,
Bimlitan village,
in the joint name of the petition.
standing in the joint name, which to stand recorded in the joint name of the petitioner's hearing. ঠিক আছে? Stopped. আচ্ছা, based on that application, the Tahsildar proceeded as per the provision of regulation section.
161.
It is section, it would be regulation.
The regulation.
Regulation 161.
They're called section.
Oh, acha, regulation 161 of in Iceland or land revenue and such 1966 stopped, and ultimately directed the concerned respondent before him to vacate the unauthorized occupation of an area of 22 square meter from the land. Stop. It is the case as has been sought to be presented before this court by the petitioner is that the petitioner, that despite being approached on repeated occasion, the Tahsildar concerned did not take any fruitful, any effective steps to implement the order dated 7th March 2023, which compelled him to prefer this petition. Stop. Acha. On 29th January 2024, when the matter, the petition was last taken up for hearing, then Ms. Das submitted that the order passed in RC case number. So it is called RC case number such and such 109/TPB/2022 was missing. However, today at the time of hearing, today during in course of hearing, he submitted that the file has been located. ঠিক আছে? Stopped. Acha. Mr. Kobir, learned advocate representing the private respondent,
No, man.
representing the
I am representing respondent number 3.
respondent number 3 is a private respondent. Representing the respondent number 3 submits that that respondent number 3 has been improperly joined, and this petition is back for misjoinder of parties. He submits that the respondent number 3, by taking a specific stand, has categorically stated before the Tahsildar that if is any encroachment of the land in question or any portion thereof has been made, the same has been done by her husband, not by her. Stop. Despite this stand being taken by the private respondent before the Tahsildar, the respondent number 3 has been improperly joined. Stopped. He submits that the name improperly joined. And stop. Inviting my attention of the order dated 7/3/2023, he seeks to contend that the entire order is directed against against Sri V. Sajvi. Stop.
Right.
Acha. Stop. However, advancing argument on merit, he supposed that unless the physical inspection of the land is made and the encroached portion of the land is located, the order dated 7th March 2023 cannot be implemented. Stop. Achha. Having heard the learned advocate appearing for the respective parties, ঠিক আছে, though I am express my agreement with Mr. Kobi that the respondent number 3 has been improperly joined. I am though sketch this portion though. And
a sentence. Doctor said that the encroachment has to be identified. But kindly mention that the encroachment that here order says 22 square meters.
Achha, 22 square meter. Last portion, encroached portion measuring or comprising an area of 22 square meter. ঠিক আছে? So name of the respondent number 2 is struck up from the cost title of this petition. Stop. And I am of the view that there is no use of keeping this petition pending. Stop. Hence, this petition is disposed of by directing the Tahsildar concerned to take all follow-up actions to implement the order dated 7/3/2023. ঠিক আছে? But before implementing such order, and physical inspection shall be made to locate the encroached portion of the land of the encroached portion of the petitioner land before taking any steps for implementation of the order dated 7th March 2023. Stop. Enter exercise shall be carried out within 2 months from the date of receipt.
2 months.
Those two
Because
parties are there,
demarcation
that
was already
tribal
done
conventions are
earlier
there.
also. Because
Again,
they-
2 months, excluded. From the date of receipt of a copy of this order. ঠিক আছে? It is made clear that I have not gone into the merit of this petition. All points are left to be decided কিছু নয়। আর দরকার নেই।
Your lordship
Last
only
point.
says affidavits have not exchanged. No.
Since the petition has been disposed of without calling for affidavit from the parties, the amendments made in the petition shall be deemed to have been not admitted. ঠিক আছে? With this observation and order.
Obliged.
Okay.
ঠিক। I can go to 6.
2 to 6.
Other due to appear
Tomorrow, yes.
Not even
I will.
I am appearing for the respondents. I also inquired, not in the notice, it is mentioned as 6. I'm sorry.
Okay. Come tomorrow. He is appearing for respondent. Are you appearing for the respondent?
No, my lord. It is the resolution.
Your unfortunate father is before this court by filing the present date. Lord,
7.
And for the respondents, my lord.
Oh.
Except
his daughter,
My lord, I am for
Kavita?
respondent number 1 and 2, my lord.
1 and 2 Andaman and Nicobar administration and subdivisional
My
magistrate
lord.
and station house officer.
I am for
You are, yeah. What happened?
petitioner's daughter
on the fateful day was found hanging in a room earmarked as storeroom, which was under the active possession of petitioner's mother-in-law. Now, UDFIR was initiated. The inquiry was rolled up. Finally, it culminated in closure. These actions have been questioned here. But on the day when the body was brought down, inquest was held. But before the sub-divisional magistrate, rather the executive magistrate conducted inquest. But I'll just show the anomalies, lordship, as would be evident in the inquest report as well as in the postmortem report. Because the line of inquiry and investigation which is desired was not done. And what the police says, some witnesses were examined, including the petitioners, but it was not done so. Just to cover up the truth, in a perfunctory manner, the inquiry was done. It's coming for the first time, lordship. They may have to say many things with reference to my papers. They have a right to say so. Let them file opposition. My point is, lordship, let them file an opposition. Let them come with a concrete stand so that the matter can be thrashed out finally. That's my point about it.
Lord, so he also intends to file affidavit in opposition. Certain allegation against the police authority. UDFIR was chalked out, Lordship.
No, he has filed a complaint.
Never
UD
filed.
case was
No,
started,
no,
but
Lordship, not like that. Lordship, what happened? The victim, 18 years victim, was found hanged in the storeroom of the maternal grandmother of the victim. She has some problem with the parents. She stated before that. The mother-in-law, that is grandmother, stated during that examination that she has some problem with the parents. One day, that is 11th February, she came to the grandmother's house. Thereafter, she was alone. She was using phone. Thereafter, she was not found. Grandmother, then searched here and where, found in the storeroom in the hanged condition. UDFIR has been lost. No complaint at all from side of parents of these victims first. Then body was taken by the neighbors and the relatives to the PSC hospital. Then police has came to the conclusion and information that one dead body was found. Thereafter, police rushed to the hospital. Then executive magistrate present there. Inquest was done properly. Then the dead body was examined by the doctor. PM report is there. That what is the reasons of that death? Then automatically, it is settled principle of law. UDFIR, it was found that it is for unnatural death. No complaint, no allegation before or after the incident.
you have not done
Everything
complaint.
was done. Lord, this is the fact. Leaving aside other things, Lord.
So we intend to file
Inquest
affidavit of opposition.
ought to have been done on the very spot. Lord, show it was done in the hospital.
Lord, see,
Maybe.
police did not do it.
Who removed the body? Those
Really?
witnesses were not examined. It's the version of the police agency that some of the co-villagers have removed the body, cut the sari, and brought the corpse to the hospital. Those witnesses have not been examined. Now let them file the opposition. That's what I'm saying.
Intends to file, yeah,
There's no
opposition.
scope for any interim order. Let them file the opposition.
Acha, having heard the learned advocate representing the respective parties and upon perusal of the report, ঠিক আছে? তাহলে আপনি লিখে ফেলেন তো? আমি কিন্তু চুপ করে গেলাম। মানে অনলি টু গিভ ইট, আপনাকে একটা বোঝানোর জন্য আপনি কিন্তু শুনতে পেয়েছেন, কিন্তু আপনার অভ্যেস হচ্ছে জিজ্ঞেস করা। তাহলে হ্যাভিং হার্ড কি বললাম? Appearing for representing the respective parties and upon perusal of the materials on record placed before me, I am of the view that there is no scope of passing any interim order at this stage, and the writ petition should be decided finally after exchange of affidavits. Stop. In view thereof, let of affidavit in opposition be filed within
4 weeks. 4 weeks.
4 weeks. 4 weeks. Reply if any,
1 week.
file within a week thereafter. List the matter for further consideration. ঠিক আছে, 4 weeks, 1 week, 5 weeks. After 6 weeks, in the next available circuit bench, comma, subject to its convenience.
Great.
Obligation.
Okay.
And for the respondent.
Page number 14.
14.1.4.
For a voting register.
Yes.
Petitioner's name appear in the record of holding register. Petitioner's particular piece, record of piece of land.
Survey number 1397.
Yes.
Yes, area such and such, land
Record
legal.
of the land.
Uh,
Now see,
You are the tenant,
and the record of tenant.
recorded
License has
tenant.
been given in my favor.
Yes.
The petitioner applied for the no dues and non-encumbrance certificate.
No dues and,
Non-encumbrance certificate
yes.
to Tahsildar Port Blair.
Uh,
But Tahsildar Port Blair has rejected the same. Because
Rejected such your prayer.
yes,
Page
and
18. Page 18, the remarks
number-
column. Why
Oh.
it was rejected? Page 18, P2. My lord, right hand side, my lord. Remarks
yes.
Column.
Uh,
As per the report of the Tahsildar, the subject land is not free from all encumbrances, hence rejected.
what is the reason? My lord? You should give the details reason why they.
No, what you say, you pay for what certificate?
And non-encumbrance
Encumbrance
certificate.
certificate.
So you have got the answer.
For
The
sale.
land is not free for encumbrances.
No, it is three to encumbrance, my name. Where is the
No,
report?
others are there, not a single one. My lord,
They should
kindly
give a
please
detail.
come to the
They
record
should-
of rights. Record of
should-
rights, page 14.
Yes.
Others are there. Joint mutation.
Joint,
is
okay,
allowed.
my child, the children. There's a.
Joint mutation can be stated to be encumbrances.
My lord, not for that reason.
No reason.
Whether he has given mortgage or not,
Yes, that is.
whether any encumbrance, that means any liability has been
Yes.
imposed there.
That is not
Reason
there.
has not been assigned in page 17, 18, my lord.
So you file affidavit.
That's fine.
Huh?
That's a file affidavit.
Oh, yeah, same order. Yeah.
Encroachment, they have encroached some portion
No,
of
no,
land
no,
for
no,
that
no,
reason.
file affidavit.
Because it's not
Affidavit
clear.
file.
Because Today is the
Ah.
first day, my lord.
That's a
That
file
day
affidavit.
is not clear.
Yeah, same order. Same order. Same order. Affidavit.
2 weeks, 1 week, my lord.
Mm.
Obligement.
Next. Nine.
My senior is appearing for the respondent authority. Is in court number 2.
Oh.
Nine.
So not today.
Not today.
Or Nani is appearing for the respondent, respondent also. You are for the respondent,
My senior-
petitioner. So next circuit bench.
Let it be not today. Madam.
Why? Next circuit will be possible. Not today.
Not.
Yes.
Item 10, CR 56 of 124.
Item 10, 9. It is 9. 9. Before that, 8. Oh.
Item 10, CR 56.
Lordship, I am for the petitioner, Lordship.
Yes.
For the respondent number 1.
And
Ah.
the state, Lord,
Oh.
in connection of maintenance.
That matter, Lordship.
So what do you want? They will fight, you will see it from a safer distance. Huh?
State should save me, Lordship.
Huh?
State should save me when something wrong has
No,
happened.
he is standing far behind. What do you want? They will fight and you will see it from a safer distance.
No, Miller, he is for the trial court judge.
No.
No,
No.
For-
Trial court judge, he is for the state.
For adjudication of the matter, I can submit that.
Yes, you stated that no appeal is
Maintenance.
maintenance. Yes.
My lord raised a valid point. That he has to file appeal. Number 1. Number 2, my lord, he filed application under section 128 before the Leonard Court below. Kindly see the impugned order first.
My lord, I am for the respondent. Let him submit first.
Now you have raised the maintainability point.
Yes.
Don't say court considering all these aspects has afforded an opportunity to you. When maintainability point is raised, then the person who has raised this point, yes. Because it can be disposed of even at the outset.
Yes.
You go, it is not
Family
maintained.
Courts Act 1984, my lord.
Family Court Act.
Family Courts Act.
Yes, Family Court Act. Yes, section 19.
19(6) may be seen. Prior to that, page 26(7) may be seen. Prior
20.
to that, page 27 of the petition, page 27. Whether it is final order or interlocutory order, Lordship kindly appreciate this point first. It is a final order. This order was passed in the year 28/11/2010 for two daughters and a mother. Not for one person, it is for three persons. I may be permitted to read. After compromise between the parties, this maintenance case is settled in the following terms. For the time being, the husband will pay the sum of ₹5,000 per month to the wife, who shall spend the same amount on account of maintenance for herself and also for the two daughters. Lordship kindly take a note. Two daughters, which includes their educational expenses also. Therefore, 5,000 divided.
Now the age of your daughter?
Both the daughters married.
Married. So attain the age of majority. It is admitted position.
At that point of time when this order was made, already they were married.
Yes,
Already they were major. And kindly appreciate Lordship, the order does not state anything that after the daughter will attain the age of plus 18, the maintenance will get. It says nothing about that, Lordship. And it is the order of Lok Adalat, Lordship. 2010 Lok Adalat.
When they have been married off.
Lordship, they have married after that time, but at that time when the order.
The exact date. We do know the exact date.
My lord, I will come back tomorrow, my lord, after getting the information, date of marriage and all.
Lordship,
I
that is.
also do not.
Lordship, kindly appreciate that is not there. Earlier, my learned seniors made a submission that on the point of minority, he is going to place some judgments. And today was a fixed, Lordship. And this. And,
Okay.
Let me submit.
The court is collecting information. What? Yeah, about the facts. Yes, continue.
I do not know the exact date of marriage.
Okay.
Your Lordship wants date of marriage, kindly pass it over for 30 minutes. I will talk with my client. I'll get the information. Thereafter, this matter may be taken up, or otherwise it may be taken up tomorrow.
Okay, you make your submission then.
Now kindly see, the wife shall, after paying the school expenses, will supply the original document to the husband in the order, who will immediately reimburse the exact amount which the petitioner wife paid from the following month of the date of production of the receipt documents. The above payments will be made by way of depositing the amount in the bank account of the wife petitioner, who shall supply the bank account number to the husband either by herself or through her learned lawyer for the husband during the course of tomorrow. In case of breach of either of the parties, the aggrieved party will be entitled to enforce before this award. This award is without prejudice to the rights and contentions in the pending proceedings or future proceedings if commences by either of the parties. Let a copy of the award be communicated to the Department of the husband at once. Both the parties shall get certified copy, 2 copy of the order, free of cost. This kindly take a note when this order was passed, 28/11/2010, 15 years before. Now kindly see when this application was filed. Before the learned court below, 13/2/24, page 18. Well, my first point is that 5,000 for 3 persons. My second point is that the wife has to provide the details of the expenditure towards the daughter. She has not provided anything from that order. Order was passed on 28/11/2010. She has not filed any documents. She has not shown any.
I am
document.
not determining a question of fact.
Your Honor, my lord.
Learned court below has stated that under section 156 425 clause 3,
Yes.
the application has not been made
In
as
the year.
per that within the time prescribed
It
there.
is there in the year itself.
Oh.
It is there in the law itself that 125(3), the limitation is prescribed. I may be permitted to read that. 125(3) may be seen.
You developed a habit of hearing first before saying anything. Now, the learned court has rejected their application.
Yes.
Now, they said that it was not an application under section 125(3).
My lord.
It was an application under 128.
Grateful, Lord.
So, learned court below has
No, it is interconnected.
Oh.
Yes.
what is their submission?
Their submission.
What is your submission? Forget about the same. It is I want to shorten the scope of limitation.
Correct.
I shall not give you all entire day. If within short span of time you have the capability to comprehend at the point of law raised by your learned friend, then argue. Otherwise, I am keeping in the next circuit. Do it for the whole day. So it is his contention that it is an application under section 128. So no limitation is there. So learned court below has committed error. Now you raise this point that this appeal is not maintainable.
Because it is to be filed before the family.
So you say this thing, give this answer, this appeal is
Maintainable.
not maintainable or not. Whether they have married, whether they were such and such,
That is
it is
not
not
fact.
my lookout.
That is
Grateful.
on facts.
Grateful.
Kindly see.
You.
In Family Courts Act 1984, section 1906. 1906.
Yes, tell that. It is a revision.
Grateful.
Here jurisdictional error relating, indicating the
It is not
jurisdiction.
interlocutory, it is a final order. Matter was disposed of finally.
Yes, tell.
Kindly come to 1906.
96.
An appeal preferred under subsection 1 shall be heard by bench of consisting of 2 or more judges. My respectful submission before your lordship is that this is not an interlocutory order. This is final order. Therefore, appeal will lie before the division bench, not before the single bench. This is my respectful submission. If your lordship holds that it is maintainable, then I will argue on merits. It is not filed under 482 CRPC. Kindly see the nomenclature mentioned in the application.
Okay, according to maintainability. Now, you say about the merit.
If lordship holds that it is maintainable, then I will argue on merit.
Assuming that court has held that it is maintainable, you now come into the merit.
Yes. Now kindly, merit being filed, kindly come to the impugned order. Pass page 11. Page 44.
Yes,
May I read the order?
but relevant portion only.
Page 45, last paragraph.
Only the relevant portion, not entire order.
Only 2-page order, my lord.
What portion of the order you want to draw my attention? Say.
My lord, only 2-page I may permitted.
Okay, go on reading.
Today is fixed for passing order in respect of application under section 128 CRPC filed by the petitioner on 13/2/2023. My first point is that the parent order was passed in the year 2010. 2010.
You have stated, don't
Yes.
repeat.
It reveals from the record, Learned Counsel for the petitioner stated that the petitioner has filed this application for enforcement of monthly maintenance allowance, which was passed according to the compromise arrived between the parties on 28/11/2010 before the Mega Lok Adalat, wherein it was agreed that the respondent will pay 5,000 to the petitioner as monthly maintenance. The opposite party used to pay the maintenance amount till 2019, but all of a sudden after he stopped paying maintenance amount to the petitioner, he further appears that the petitioner is entitled to get maintenance rupees 5,000 for the period from 1st October 2019 to 30th September 2020.
at the rate of rupees 60,000. The opposite party, being a regular government servant, did not come forward to pay the arrears of maintenance, deliberately avoiding to pay monthly maintenance amount. Petitioner is 53 years old lady, is totally depending upon the opposite party, and as such, non-payment of maintenance allowance. The petitioner is suffering badly, as such the petitioner is in need of enforcement of maintenance order passed on 28/11/2010 before Mega Lok Adalat. The opposite party willfully and intentionally did not pay the maintenance amount to the petitioner. As such, she filed this mis-execution case for recovery of arrears of maintenance for the period from 1st October 2019 to 30th September 2020, that is rupees 60,000. On the other hand, the opposite party entered appearance through his learned counsel and stated that miss case number 122 of 2008, dated 28/11/2010, the Mega Lok Adalat passed the order stating that for the time being, the husband will pay sum of rupees 5,000 per month to his wife, who shall spend the same amount on account of maintenance of herself and also for her two daughters, which includes their educational expenses also. The wife, after paying the school expenses, will supply the original documents to the husband, who will immediately reimburse the exact amount which she paid from the following month of the date of production of the receipts. The payment will be made by way of depositing the amount in the bank account of the opposite party wife. The opposite party, by filing written objection, submits that the petitioner has not come before this court with clean hands. She has not filed any document to show till September 2019 she was receiving the maintenance. How she has spent the maintenance amount for the education expenses of the minor daughters. It also appears that in the order of the Mega Lok Adalat, she is also the receiver of maintenance amount for the daughters, and the order of the Mega Lok Adalat is not clear in the situation when the daughters will attain the majority. What shall be the quantum of maintenance to be paid to the petitioner? It is alleged that the petitioner suppressed the fact that the daughters have attained majority and are settled in their own life and completed their education. The opposite party, that he is in contact with the daughters and from time to time provide financial aid to the daughters. And at no point of time, the daughters have never come before honorable court by filing an application for enforcement of the order. From September 2019 to till date of filing of the filing, nowhere in the application the petitioner has stated that how she was surviving. This application is filed only to harass the opposite party. It is submitted that the petitioner has not come before this court with clean hands and has suppressed the order passed by the Mega Lok Adalat in entirety. And as such, the instant application filed by the petitioner is liable to be rejected. Third, learned lawyer for both sides, learned lawyer for the petitioner, submitted that there is no bar to give maintenance to the petitioner. On the other hand, learned lawyer for the respondent submitted that as per the provision of section 125(3) CRPC, the petitioner is not at all entitled to the maintenance. Having heard both sides and also having considered the facts and circumstances as prescribed above, it is also found from the gracious judgment of the Honorable Bombay High Court in 1988 SCC Online, Bombay 377, that warrant cannot be issued for a period in excess of 1 year in respect of section 125(3) for recovery of maintenance amount, as mentioned in the case of Gunvat Kavado versus Kavado Narayana Rao Katoro. In view of the submission advanced by both the sides, and also perusal of gracious judgment of the Bombay High Court, and also in view of section 125(3), I find that in view of section 112(3) CRPC, this petition is not tenable as prayed for because it is beyond the time limit, hence liable to be dismissed. The application under section 128 CRPC filed by the petitioner on 13/2/2024 stand dismissed on contest. Well, my respectful submission is, what is the error in the judgment? I am asking myself. There is nothing, no error in the judgment. The limitation is prescribed under 125(3). Now kindly see 125(3).
Why?
The parent order was passed 125(3).
120, he is claiming 128.
128 directly.
He made application under section 120.
Now kindly see 128 also. 128 maybe.
Read for me. For a
A copy of the order of maintenance or interim maintenance and expenses of proceeding as the case may be, shall be given without payment to the person in whose favor it is made, or to his guardian, if any, or to the person whom the allowance for the maintenance or allowance for the interim maintenance and expenses of proceeding as the case may be, is to be paid. And such order may be enforced by a magistrate if any place where the person against whom it is made may be, on such magistrate being satisfied to the identity of the parties and non-payment of the allowance as the case may be, expenses due. Well, this 128 enforcement directly will not come into play. We have to see the entire chapter. The limitation is prescribed 125(3). Now kindly see 125(3). One 125(3) may be seen. Tactfully filed the application in 128. The court rightly.
125(3), another mode of recovery. Court will see within 1 year,
Yes.
then distress warrant. Is distress warrant is not near,
Warrant of arrest.
then warrant and 125(3). You kindly make it clear, it should be clear that if order once passed, your liability will not go. Civil suit can be filed
Yes, that is the judgment I am going to.
to
take by,
recover. You don't say unless it is modified under 127. If you go on shouting that my wife has gone elsewhere with any other person, my daughter has attained majority in the meantime, I have supported them.
My lord,
That
it is
will not.
not in the order itself, my lord. Kindly appreciate
Which,
it.
who prevented you
My lord, it
to
is-
file 125 to 27 application and bring this subsequent event to the notice of the London
You have to
magistrate?
kindly appreciate one thing.
You have not done it.
No, no, kindly.
Now there is a revision. Revision means question regarding to the jurisdiction of
My lord, it is not filed the revision.
Pierre,
Kindly
we
see.
shall not hear only the so much of the fact which is required for the purpose of disposal of this revision application. What happened, where he was so long, the court is not concerned.
My lord, 5,000 first of all, my lord, 5,000 is for not for the petitioner alone.
You are not giving answer to the question raised by here. That he has filed application under section 125 or 28,
28 days.
but the London Court will has rejected his application saying that it is barred by limitation prescribed 125(3).
Nothing wrong. in
What
the
is your
order.
answer?
My answer is that, my lord, in similar matter.
Okay.
Similar matter, Calcutta High Court also passed.
Okay, Mr. Karmakar, what is your submission?
My lord, no.
Judgment, yes, give the judgment.
I am giving the judgment. Coordinate bench passed the order
Mhm.
on limitation.
Mhm. Yes.
He is not remediless, my lord, he has to file a civil suit. If he want the entire amount from since beginning, he has to file a civil suit for recovery of the.
It is a
entire amount.
application was itself filed under section 125(3), not under section
It
120.
is interconnected, my lord, it cannot be,
Okay,
taken
okay,
separately.
Okay.
It cannot be taken into account separately. It is coming under the same chapter. You have to see whether it is filed within 1 year or not. The court rightly passed the order. It is not, admittedly, it is not within a year.
So only a remedy available in a person to enforce the order 125(3).
Yes.
Except this, no other.
The yes, 125(3), there is a limitation is prescribed 1 year.
Oh, okay. Okay, next.
My parent point is that the petition itself is not maintained because appeal is to be filed
Okay.
under section 19 subsection 6
Mhm.
before the honorable division bench.
Okay. That's all?
That's all.
Yes. Yes, Mr. Karmakar.
Lordship, as 125(3), the limitation is for issue of warrant for recovery of that money. First, 125(3). But 128, that is a specific mention as enforcement order of maintenance. That power also have given to the magistrate under 128. As per my understanding. 125(3), that is one limitation for the due date 1 year. But this power also given last portion. As such order may be enforced by any magistrate in any place where the person against whom it is made. That is 128, last portion.
Yes.
Last portion also. And such order may be enforced by any magistrate in any place.
Under which procedure it would be enforced?
That chapter is 125 started. Procedure is 125 started. That is chapter. 125(3), a specific limitation has been given. It is settled principle of law. Because within a due date 1 year, if somebody will not come for enforcement of that order, the court cannot pass an order for enforcement. 125,
According to 125(3).
125(3).
No warrant is be issued.
Lordship. But 128, I also found by reading this,
It is another mode of.
mode
of
some
enforcement.
power has been given to the magistrate.
So you are supporting the petitioner.
Not supporting for proper adjudication of the case.
Okay. Another mode of recovery. Okay.
Only for proper adjudication as per my
No.
knowledge.
Always. Yes.
So some power given under 128 for enforcement of the order. 125(3), time limitation is prescribed.
Yes.
That is my respectful humble submission.
And regarding the maintainability of the appeal, the revision, it is a maintainable.
Lordship, revision, if illegality, irregularity found,
It's maintainable. Okay.
maintained.
Okay.
If irregularity,
Anything in reply?
but
Yes.
in family court, Lordship,
Ah.
boliye.
Lordship, my learned senior has stated 19 subclause 6. Before that, we need to go 19 subclause 2, which says that under chapter 9, all will lie under revision. I have filed a revision. Chapter 9 talks about 125, 126, 127, 128. And also mutual consent order. This is a mutual consent order for which I am filing it. I have filed a misexecution case. Lordship, second aspect my learned senior has stated that she has not given the money, she has married or not. Kindly appreciate the scope of 128 and 125(3) are very limited, only confined to the enforcement of the maintenance amount. Here, if this honorable court has rightly stated this thing, if you want something that you want to show the court, you need to file in proceedings under 127. There is a remedy. If there is something that the wife has married again and the amount that is not, they're feeling that is more or less, their remedy goes to before the honorable family court under 127. But they won't be filing 127 because an order of 5,000, if they go to honorable family court, the family court will definitely give order of more amount. Company appreciate that. Third, Lordship, regarding the maintainability point, Lordship, I have given 3 judgments, Lordship. And all are stating that according to 19.4, all will come under revision and it is maintainable. Apart from that, it is not filed in if it is not maintainable also, this honorable court has got power that leave may be granted and kindly appreciate I have filed a revision under appropriate thing and under 94, which is exactly correct, Your Honor. I have given 3 judgments which support my contention, Lordship. Lordship, kindly appreciate a woman who is 53 years old. My learned senior has made a point that for past 14 years, where was I? He was paying me from 2018 to 19. Suddenly in 2019, he stopped paying. After that, Lordship, kindly appreciate that date, Lordship. 19, 2020, 21, 22, 23. These dates were at the time of the COVID pandemic, Lordship. I was in mainland with my daughters. Lordship, Honorable Supreme Court has passed in judgment for the limitation. this judgment is a very celebrated judgment. This honorable court, this judgment which says for the limitation. For argument's sake, Lordship, if I have filed this application under 125(3) also, this should not be rejected since it is a beneficial legislation, and this judgment also saves the petitioner from this, Lordship. Because in this, all the limitations were enhanced at 2000, Lordship, to 2022, Lordship. This is the that judgment, Lordship. Lordship, apart from that, Lordship, there is this difference between 125(3) and 128. Family court is a legislation which is for the benefit and upliftment of women. If a woman does not able to go before the court at time, she can always file a case under 128 and she can get an enhancement amount. Kindly appreciate the scenario, Lordship, where a woman is running from post to pillar to get his rupees 5,000. He goes before the family court, files 3 misexecution case. From 2019, she is without a single penny, Lordship. She files the case in family court, and after this, she comes before this family court. The litigation charges and all. Kindly appreciate that scenario, Lordship. Lordship, for supporting the claim, I have given 3 judgments, Lordship. I will place 1 judgment, Lordship, before this honorable court.
You placed for realization or improvement of the from 1st October 2019
Yes, Lordship.
to 31st November 2020.
Yes, Lordship.
And this judgment suo motu limitation is March 2022.
Yes, Lordship.
Huh?
Yes, Lordship.
Yes, 15th March 2022. 22. When the interim order was.
And after that, there is also a grace period of 90 days, which may be extended to 180 days, Lordship. And Lordship, kindly appreciate these are for all proceedings. For under 128, there is no limitation. Still, I have placed the judgment before the honorable court to impress upon it, Lordship. Kindly appreciate that. Because the time of 19, 20, 21, 22, we've all faced the COVID-19 pandemic, Lordship. Lordship, I have stated that under 128 there is no limitation. Lordship, I have placed 3 judgments. Lordship, I will be reading 2 paragraphs of the 1 judgment that I have given, Lordship, of the Madras High Court S. Nagamuthu by Honorable Justice S. Nagamuthu in the case of P. Vaiti versus Kannaveli and other. Lordship, I will just place 2 paragraphs, Lordship.
Have you given copy?
Yes, I have given a copy. I have given a copy. I have also given a copy to the honorable court also, Lordship.
Yes, what is the proposition of law?
Lordship, in this it is said that under 128 the proceeding may be filed, and under 128 the enforcement can be done by an order, and there is nothing. Lordship, in the main thing is the honorable court, the honorable High Court of Madras High Court has categorically stated that in under 128 there is no limitation. I have placed that judgment, Lordship, before this honorable court. Lordship, I am summing my submission, Lordship. Kindly appreciate a scenario, Lordship. A woman, 53 years old.
Okay.
Kindly appreciate, Lordship. She is without a penny from 2019, Lordship.
Well, at one more point I missed.
Yes.
That very important point. Admittedly, the maintenance amount of rupees 5,000 was granted to petitioner as well as to 2 daughters. Initially, 2010. After majority of the daughters, they married. The petitioner has not filed any application before the family court. Separate application, stating that now I am claiming separate maintenance amount. Kindly take a note of this. Wife has not filed a separate application before the family court for claiming any maintenance. That earlier maintenance is for 3 persons. Kindly take a note of this. This is very important. She is not entitled for entire 5,000 amount. She is entitled 5,000 divided by 3. 1 share she is entitled.
On that date, on earlier date, you made this submission.
Well,
Then I ask you not to raise this point.
this is,
It is a question of fact first.
it is
At
reported.
that part you say that it was my daughter. So legal disability will apply under Section 6 of Limitation Act. So long they will marry minor, the Limitation Act will stop.
Now they are.
will not stop. to
Now they
operate.
have not entered because of they attained the majority, they married, they are residing separately.
Okay. That fact has not been brought on record by any of you.
She left my society. She is residing somewhere else. in
Okay,
Chennai.
okay.
Husband
So
already
all
married.
Question of fact. Problem is that all question of fact, you never cannot read the mind of the court. It is a revision.
No, madam, I know the court is, this is beneficial
Which is-
legislation.
Revision is legality, propriety and
Correct.
correctness which will indicate towards jurisdiction.
I
When
understood.
court is trying to find out the answer, that 125(3) or 125(a), and
The question
appeal
is
is
very short.
maintainable or not,
Very short.
Then,
Question is very short.
my lord, he has left me, my daughter has attained majority,
No, if
that is
suppose,
not fact.
madam, kindly appreciate. If
Okay,
suppose-
hard.
No, if suppose.
I'm grateful, Lord.
10, 11, 12, hard.
Kindly appreciate. If court told that is entitled for maintenance, then 5,000 she is not entitled. That's the reason I have to point out before this court.
For that, there is 127 proceedings. For that is 127.
This is very important point, madam. It cannot be.
Very
accepted.
important. Yes, very important. Okay, shall be dealt with accordingly.
Madam, this judgment may be seen, passed by the coordinate bench judgment.
Yes, it will be
was
dealt
clearly
with.
mentioned everything.
Ah,
Even
yes.
Supreme Court judgment is also quoted.
Yes, hard. At 11 and 12 also.
Identical matters.
Hard.
Same here, Lordship.
Hard.
Grateful, Lordship. Grateful.
Hard. Next, 13. तीन है.
For the petitioner, CBI, Mr. Govind appears for the petitioner, revisionist, my lord. We are praying, let it be in the next circuit due to his personal difficulties, will not be doing. it.
कितना?
My lord,
अच्छा,
the revisionist.
अच्छा.
state
On the basis of the prayer made on behalf of the petitioner, let this matter let the matter appear before the next circuit bench subject to his convenience. Yes, 13,
Grateful.
14.
I for the respondent state. I for the state.
Okay, next circuit. 15. 15 also. Okay, next circuit. 16. 16 to 23. Okay, next circuit. As per their prayer. Okay. Based on the prayer made on behalf of the petitioner. But based on the prayer made on the petitioner, the matter, let the matter be placed before the next circuit bench, subject to its convenience. Next.
Item 24,
Yes.
Proceed. In all cases, I am appearing from the state. That will be recorded in my presence.
Oh,
That will be.
ওনার অ্যাপিয়ারেন্সটা দিয়ে দেবেন সব কথাতে।
This is an application for rushing to pending because the lower court, the high court, under tax and property tax.
Is your other side?
In this matter, I short time other day to take instruction from the department. The on inspection of the drug had been to put there. The matter was discussed as well. And I asked some other documents with regard to the pending matter in the lower court. Within the next 2 days, other lawyer will be able to provide me the documents. So that will post to the next one. There is an interim order operating. That will be extended. No problem, that will be extended.
Till the end of February. Another year is coming. Acha, as paid for on behalf of the Union of India, on behalf of the learned advocate appearing for the respondents, leave the matter for further consideration in the next circuit bench subject to his convenience. Yes.
Item 25, PRR 1 of 125. Item 25, PRR 1 of 125.
Next circuit.
I am for this state. For this state, Lordship.
Okay, next circuit. Hey, your Dr. Karmakar is appearing. 26.
For the state. Lordship.
Passover. Tomorrow, not today. Okay. Will you stay here? Huh?
So I just yesterday I also received. Yesterday I received.
So not today.
Not
Item 27, CO 40 of 123.
Lord, I am appearing for the respondent number 2.
Hmm.
My lord will see the last order, my lord, the revisionist is not coming forward before this honorable court. As such, because the respondent number 1 and the revisionist, there was a certain settlements have been done, and so that they are not pressing this application. So for several occasions.
Pardon, Your Lordship, I'm appearing on VC.
For opposite party number 1.
You are for?
I'm for the respondent number 1, Your Lordship, for SN Kanungo, the original decree holder. Lordship, may I please, Your Lordship, may I submit, Your Lordship?
Yes.
Your Lordship, may please kindly refer to the order dated December 12th, 2024. Mr. Das was appearing on the behalf of the petitioners. So he's not appearing, and notice was also issued. They are continuously not appearing from last 1.5 years. And as per their, we have already submitted the affidavit that the matter has been settled, and the decree holder has already withdrawn the entire amount.
Oh.
So the Lordship may kindly dismiss the application because this case has become infructuous.
Okay. Yeah.
Item 27 and 28, Your Lordship.
Yes. Record reveals that the petitioner has not appeared. The petitioner did not appear. But petitioner did not appear. The petitioner remained unrepresented on several occasions. The petition record reveals that the petitioner remained unrepresented on several occasions. Stop. Even so the petitioner did not appear on 20th January 2025 when the matter was last taken up for hearing. Stop. Today also none appears to represent the petitioner. Stop. Nor is any accommodation sought for. Though Mr. Karmakar, though your name please?
Rakesh Kumar, along with
Though Mr.
Senior Counsel Satadul Chakra
and Mr. Kanungo, learned advocate representing the respondent number 1 and 2 are present. Stop. It appears that the petitioner is not interested to proceed with the matter. Stop. In view thereof, the matter stands dismissed for default. There was any interim order?
No.
No, Your Lordship. No, Your Lordship.
Dismissed for default. Next.
Obliged.
Same order one.
Same order.
Same order.
Yes, sir.
28, same order. Next.
Obliged.
Obliged.
Item 29, CO 33 of 122.
The service was not affected for different other respondent was 9. So we
Oh.
tried our level best so that it is the next step will be.
as paid for, as paid for, let them, as paid for on behalf of the petitioner, let the matter placed before the next circuit bench, comma, subject to his convenience. Yes. 30,
The petition.
yes.
This is a case, Your Lordship, where after the preliminary decree was affirmed by this honorable court, it traveled up to this honorable court. It was affirmed. And thereafter, Your Lordship, when I filed the application for appointment of
Commissioner, yes.
before the learned court below on order 26/13, that time, Your Lordship, it was found that the entire file is missing. But it was my luck that I have already got the certified copy of the entire thing. I supplied it to the learned court below. I submitted to the learned court below that file should be reconstructed because if the file is missing, what
Yes.
can I do?
Yes.
But Your Lordship, since last 2 years, my matter is pending, Your Lordship. Every time record is called from the district record room, the answer is that we are searching.
You are?
For a respondent, Your Lordship, not to.
So you cannot have any objection
Your Lordship, tomorrow, Your Lordship.
tomorrow?
Your
Why?
Lordship. My senior is appearing. My senior, Mr. Arul Prashant, is appearing, Your Lordship.
Okay, come tomorrow.
Item number 14, there is an order there, this is only dated on September 3rd. The proceeding.
29. Who is 29? They are facing now.
Therefore, legal that, and I beg pardon. The proceedings of the lower court has to be stayed. There is an order that the proceeding of the lower court has to be stayed, Your Honor. Justice Vishnu Chaudhary, order dated 3rd September 2024.
When the matter next circuit
Okay,
possible.
beg pardon.
Only one day to whether it would be fixed or not, I don't know. Give it. Whether there any interim order was there.
Yes, yes, ma'am. September 3rd.
I think already when I have placed up to February 2025, next circuit will be from 17th February. So we'll get occasion. Oh. 31.
Senior is appearing for the petition. I pray for let this matter fixed on tomorrow.
Okay, not today. CO 31.
32, My lord, I'm for the petitioner, lately not today.
Not today.
I am for the state.
Do it, I shall take it. Through video conferencing, I shall give pass order. You just complete your argument.
My lord, I have been instructed by my senior to just post the matter tomorrow. Maybe just not today, let it post it tomorrow again.
Okay, not today, come tomorrow. What can be done?
33, WPA 428 of 2024.
33.
Lordship, I am applying for the respondent.
My lord, let it posted in the next circuit, my lord. Reply has been already filed.
Yes, I have received the copy.
33 of yes, next circuit. What is it?
Hold it.
Petitioner as paid for. Next circuit as paid for on behalf of the petitioner.
34 kilometers.
34 same pair.
34 I am with the petitioner, my lord.
34, Lordship, I have, there is a direction upon me to file opposition, Lordship. I have filed the opposition, but certain mistake occurred in the opposition. So I am praying for next circuit bench. I will correct it. before the registry and let the
আচ্ছা,
matter
as
come.
paid for on behalf of the respondent করবে
Lordship,
next circuit 35 same
I am for the petition.
same lordship,
next circuit
Simple.
36
same,
Item 37,
same lordship.
item 38,
Item
For the
38
petition.
to 41 can be disposed of lordship
hmm
because similar order has been passed by honorable court number 1 lordship.
okay
So, if the same order is passed, there I have appeared through virtual mode, here online mode, in person. To consider their application in accordance with law. Lord.
so disposed of in terms of this order in the same tune, huh? You have no problem, no objection, okay. Yeah, 38 to 41
41,
40
41 also same.
41
41, I am appearing for the writ petition.
okay, same
Obliged, Lord.
41 same সেম অর্ডার কোড নাম্বার 1 পাস করেছে, ওরা চাইছে সেম অর্ডার, ঠিক আছে আপনি লিখুন দ্য বাই
Lordship, I may permitted to leave, Lordship, because. I have
okay
matters in court.
by preparing
Okay.
this application the petitioner had paid for a directive to the concerned respondent to consider the petitioner application for new electricity connection at his residence. At his residence. Stop. The Mr. Sachansar, learned advocate defending the petitioner, submit that despite receiving the application, receiving the petitioner application for obtaining for the provision of electricity connection at his residence, the same was left unattended for a the same was left unattended. The comma, the same was left unattended for a considerable unattended stop, which prompted the petitioner to prefer this present writ petition. Stop. Acha. However, having heard the learned advocate appearing for the respective parties, and upon perusal of the materials on record, stop. I am of the view that there shall no useful purpose will be served. No in keeping this petition pending. Stop. Will be served in keeping this petition is pending. Stop. Therefore, this petition stand disposed of, directing the respondent number 2, directing the respondent number 2 to decide take decision on the application petitioner application, ঠিক আছে, in accordance with law, within a period of a fortnight from date with a period from the date of communication of this order, ঠিক আছে, and the decision shall be communicated to the petitioner by 1 week thereafter, ঠিক আছে. With this observation and order, this petition is disposed of. However, there shall be no order as to the cause. Stop. It is clarified that if the petitioner's prayer is not accepted, a reason order shall be passed, and that must be communicated to the petitioner within 1 week from the date of taking suggestion. ঠিক আছে. Next, same order, 13 to 41.
Yes.
13 to 41. এটার argument 38 to 41. Now, yes.
item 42, SA1 of 125, therefore they are applying both the offenses.
We'll also plan for the respondent. Can it be taken up tomorrow election?
Okay,
I can finish it.
I can start with my lord.
Yes, it's no issue.
Able to that.
He can start.
Installment basis.
It's very short appeal, installment.
Appeal.
Second appeal.
Oh, yes.
Substantial question has been framed by the Honorable Division Bench. And
Oh.
for disposal by the Honorable.
He can give a brief, your lordship, of the facts and tomorrow we can.
Yes. Formally, I can
Continue
start
and
it.
complete.
Formally, I can start it. There's one
Hmm.
question being framed by the Honorable Division Bench in both the appeals.
So appeal admitted on the point of substantial question of law that that's misreading and misinterpreting the documentary evidence marked such and such local investigation report. Issue number 2, 3, 4 and 5. Yes.
Yes. No, what has happened? The respondent in the present appeal instituted a suit seeking recovery of khas possession of the suit schedule land. It is the claim of the respondent before the trial court that he being the recorded tenant has an absolute right, and I being an adjacent plot holder have occupied some part of his recorded land which it has been appended in the foot of the parent as a shoot land. But the trial went. We argued, we led evidence, we argued. The trial court on merit decided against the defendant and in favor of the plaintiff, holding that I have unauthorizedly occupied the shoot land. But when it comes to the point of maintainability, the court below held that suit is not maintainable in view of a bar as envisaged under local regulation 204. Had it been a suit for declaration of right title and interest with a consequential relief of recovery of khas possession, in such a case that bar will not apply. If it is a suit for simply recovering of khas possession, then regulation provides a remedy. If the suit is not the remedy, one has to approach the concerned revenue authority to seek because conferment of title is not vested with any of the regulation, any of the power. It is with the civil court. Even Honorable Apex Court cannot grant such a. It's a competent civil court having jurisdiction on the matter can grant it. There are two folded findings of the trial court. On these findings, the suit was dismissed. The respondent, being the appellant, preferred the first appeal. It's a judgment of reversal. The first appellate court has reversed it, considering the report of the local investigation. And the first appellate court have misinterpreted regulation 204 and has reversed the finding of the trial court insofar as it deals with suit not to be maintainable. That's the point. A very short question. I would show my lord the provision of law insofar as 204 is concerned, regulation 161 is concerned, and then I'll take my lord to the very report.
So the main question of law, whether it would be substantial or not, that would be it. So whether in view of the provision of 204 of such and such regulation, the suit is maintainable or not.
Yes.
It is this question.
No.
Yes.
And the misinterpretation of the report of local investigation.
You are the plaintiff.
I'm the defendant.
You are the defendant. The plaintiff says that it is not a suit simpliciter seeking a direction for correction of record of rights or anything like that.
He thought
A recovery of such and such.
Recovery of
khas possession. Claiming declaration of right title.
not required.
No, it's required.
Not required.
If a person is occupying a land of a third party, then one has to claim a declaration of title because the third party is in occupation. It may happen so, Lord, by passage of time, the right would be ripened to one who is occupying unauthorizedly. So 34 of specific leave act clearly mandates there has to be a declaration and there has to be a consequential leave for recovery of khas. That's missing in the case. That rightly was considered by the trial court.
Within how many days from the date of disposition you approach the court?
I approach them.
The plaintiff
You approach they approach the court?
within 2 years.
3 years.
Within 2, I'll show
I
that.
will also show them.
I'll show that. Within 2 years.
Within 3 years.
3 years.
Within 2 years.
Approximately 3 years.
And they have
They are
already,
most probably 2 years within
Yes.
2 years time.
Yes.
and they have already approached the
It is-
Tahsildar.
It is 30th September 1999 and suit was filed in 27 February 2002.
I'll show my lord. But the fact remains, it's owned by record that plaintiff approached already the Tahsildar for seeking my eviction. The proceeding is pending. The proceeding has not been culminated. In a haste manner, without allowing the Tahsildar to take a logical conclusion insofar as that proceeding under regulation 161 is concerned, suit was lodged. Seeking
No,
my
actually, Tahsildar within 2 years.
yes. It's
Then he has approached after expiry of 2
Which
years.
is what plaintiff says, my lord, but the record is something else. I'll show that. The record which is borne by the courts below, my lordship, something else. I'll show that. This is the sum and substance of the substantial question to be gone into, my lordship. So let it come tomorrow, my lordship. I'll draw my lords to this rest of the part of the. I'll draw my lords to the pleadings, the report of the local investigation, then the regulation 204 and 161. This needs to be seen.
Okay. So, the order is required to be passed.
Not required.
Not required. Oh, I think an order is also required to be passed. For material instruction.
No, that we have already got.
Oh, already got. Okay. Okay. Yeah. Yes.
Appearing for the respondent in item number 44 and in item number 45, Ms. Senior is appearing for the petitioner. I pray for name clearly.
Okay, as paid for cable, as paid for, you are the appellant in 44.
Respondent.
44 respondent and 45 হচ্ছে appellant. Isn't it? Appellant as paid for. As paid for on behalf of the appellant in SA 5 of 2024 and the respondent in SA 4 of 2024. Let the matter appear before the let the matter be placed before the next circuit bench subject to its convenience. Yes. Yes.
Item 46, essay 10 of 124, with 10 1 and 10 2.
Not today, your lordship, my senior appears for the respondent.
Not today.
Item 47, essay 1 of 125.
Lordship, I for the appellant, there is a delay of 16 or 18 days in this.
That is the other side.
I served copy to the other side. Owner is not appearing, claimant
Who
is not-
represented before the learned court below? Do you know?
Owner is not representing before the court below.
Okay, who is for the claimant?
Claimant I have served notice. And they also file a appeal also before this court, FMAT 2 of 2024 against the same judgment.
Oh. Acha, during the hearing, Mr. Khan, learned advocate representing the appellant submits that submits upon instruction that appearing for the appellant submits upon instruction that another appeal has been prepared by the claimant challenging the same order. Do you know the number?
Yes, Your Worship, 002
Which has been registered as FMAT within bracket MB number 2025. Stop.
24.
24. Acha. Let this appeal appear along with appeal being FMAT within bracket AB. 2024.
Circuit में नहीं. Next circuit.
Before the next circuit bench. Stop. Subject to his convenience. The appellant is asked to communicate this order to the claimants, to the respondents.
Yes, sir.
And file affidavit of service on the returnability. Okay.
Problem.
48, 68, 25, 24, 10 1 of 122.
Your lordship, in this matter, my senior appears for the petition, your lordship, tomorrow. Your lordship.
Okay, not today.
Item 39, CR 15 of 124.
My lord, my senior is appearing for the respondent number 2. I was praying for next circuit.
My lord, my senior is appearing for the petitioner. There is an increased order like 6 months.
Interim order extended Place the file. Acha, as paid for on behalf of 49, you are for the petitioner.
I'm for the petition.
As paid for on behalf of the petitioner, let the matter placed before the next circuit bench subject to his convenience.
Respondent number 2 is paying for next.
Acha, on behalf of respondent number 2 করে দিন। 2 হ্যাঁ next circuit ঠিক আছে হ্যাঁ next subject to his convenience. Stop. Interim order passed earlier is extended till the end of February or until further order whichever is earlier. Yes.
Item 50, CR 59 of 2024.
In this matter, the senior is appearing for the petitioner, say for not today.
Mr. Karmakar is appearing for the estate, Lordship.
Not today.
Let it be not today.
Yes.
Item 51, WPA 104, 2020.
We have
filed
with the affidavit service. Huh?
We have filed the affidavit service.
Okay.
And therefore,
Ready?
no, Mrs. Nath's presence would be required.
Oh.
But in this case,
So what can be done?
I am asking the reputation if the service is affected of the Union of India, a copy be provided to me so that I will be taken to take up the matter of the Union. Because I was not appointed either through Ministry of Law.
It is you give a copy.
I have already given, my senior have put his endorsement in my copies. I can give another copy of that.
I don't want that copy. I want that if the service is affected, the copy of the service, उसको copy दे दो record में sir, so that I will take up the matter with the Union Head, because I have not been appointed by the Ministry of Law, neither by Ministry of Law nor by this office. My lordship, I am asking that if the service is affected, kindly inform me the relevant document so that I will take up the matter with the Union Head.
Oh, you made this submission that you have been personally served. Since you usually appear on behalf of Union of India. But the service upon the respondent number 1, that is secretary, has not been effected as yet. So they are saying they are filed. You take information. Instruction.
Let me see. It's not filed. I'll serve once again to the authority concerned. It's not done.
So I am placing here before the next circuit. Acha. As paid for on behalf of Mr. Lal. Okay. Mr. Lal.
Information of the service is informed to me. I will take up the matter of the ministry so that I will come with proper instructions.
As paid for on behalf of Mr. Joypal Kurgu. Joypal, acha, let this matter place before the next circuit bench subject to his convenience. Yes. Yes.
Item 52, authority 8,
52.
We have filed affidavit of services
52.
today.
So who is appearing on your behalf? Against for the respondent? So not today, not today.
Let it be next.
Next circuit.
Unless it is the topic.
Or as paid for on behalf of Mr. Lal, next circuit bench.
Item 53.
53.
I am for the opposite party.
In this matter, my senior is appearing for the petitioner. I pray for next circuit.
Okay, yeah, for the petitioner. Acha, as paid for petitioner, next circuit.
Item 54, WPA 84.
54.
I am there for 54 and 55.
Who is the other side?
Lord, I am appealing with the Kodwa Municipal Council. I find my affidavit in opposition. They have sought time to file reply in the administration. They are not a performer party there because
If the administration chooses not to file the opposition, then I'll file reply against the opposition filed by the council, Porter Municipal Council.
Who is appealing for the administration? Who appeared?
In item, Babita Das was appearing in other file, Shiv Balan is appearing. For respondent number 1. Both are
And you are for?
I am in both the matters, I am appearing for Kota Municipal Council. The order which is.
So have you filed the affidavit?
Affidavit application, both the matters.
So Miss Das.
Das.
So information before the court is required whether Ms. Das is intended to file
Yes.
opposition or not. So I am keeping it not today. Ask Ms. Das to appear tomorrow and give this information.
Yes, sir.
In item number 48, my presence needs to be recorded. I am appealing for the Tahsildar concern. Not today, my presence required.
Okay, only not today. No record has been ordered. Supplementary, Mr. Both are there. Is Kormakar is there? Mr. Kormakar. Yes, I have placed this matter under the hearing to be mentioned. On that date, you stated that you are in custody for 2 months. Is any document or anything is from, it would be written from the lower court? No, lower court record is not. I have
Not the, I'm
no.
told by my client that the moment the FIR was initiated, he was put behind bar. Offense being.
And when he was released?
Let me take the correct picture, Lordship. I'm told that for 2 months he was in the judicial custody.
Oh.
He was in the judicial custody for.
No, if I record this, that for 2 months, I am told by Mr. Jayapal that.
Even then, not, since it's falling from my lord, the matter is brought as.
You over phone, you can take information.
I'll take instruction, I'll come back tomorrow. Can I come back tomorrow?
Tomorrow?
Tomorrow, is it possible?
In that circumstance, yes.
I'll do one thing. I'll take my instruction, I'll inform.
Yes.
That I can.
And if any available through WhatsApp, any order, copy of the order or anything like that.
I'll give a hard copy too.
Give me.
In course of today.
Okay.
I'm grateful.